Chapter 9, Civil Liberties. Good afternoon, everyone. Today we focus on a cornerstone of American democracy, civil liberties. If Chapter 8 gave us the framework of the Constitution, this chapter shows us how the Constitution protects individual freedom against government overreach. Civil liberties are, at their core, the do-nots of government, limits on what the state can do to its citizens. Let's start with a definition. Civil liberties are fundamental rights and freedoms that the government cannot violate. They are primarily found in the Bill of Rights and strengthened through later amendments and Supreme Court decisions. These liberties protect speech, religion, privacy, due process, and more. The Bill of Rights. When the Constitution was first proposed, anti-federalists feared a strong national government. To win ratification, the Federalists promised a Bill of Rights, adopted in 1791. These first 10 amendments include protections like freedom of speech, freedom of religion, the right to bear arms, and protection from unreasonable searches and cruel punishments. At first, when the Bill of Rights was ratified in 1791, these protections applied only to the federal government. For example, the First Amendment prevented Congress from passing laws restricting free speech or establishing a national religion, but it did not stop individual states from doing so. In fact, several states in the early republic had official state churches or imposed restrictions on speech and the press. The founders assumed that most protections for individual liberty would come from state constitutions, not the Federal Bill of Rights. That changed after the Civil War with the ratification of the 14th Amendment in 1868. This amendment was written to ensure that states, not just the federal government, respected basic rights and liberties. The key phrase is the Due Process Clause, which says that no state shall deprive any person of life, liberty, or property without due process of law. Over time, the Supreme Court used this clause to incorporate most of the rights in the Bill of Rights and apply them against the states. This process is known as the Incorporation Doctrine. The court didn't do this all at once. It happened gradually, case by case, over the course of the 20th century. For instance, in Griswold v. New York, 1925, the court ruled that free speech protections in the First Amendment also applied to the states. In Mapp v. Ohio, 1961, the court held that states must honor the Fourth Amendment's ban on unreasonable searches and seizures. In Gideon v. Wainwright, 1963, the court decided that states must provide attorneys to criminal defendants who cannot afford them, incorporating the Sixth Amendment right to counsel. And in Miranda v. Arizona, 1966, the court ensured that state law enforcement had to follow the Fifth Amendment's protections against self-incrimination by informing suspects of their rights. Today, because of incorporation, whether you're dealing with a local police department, a state court, or a federal agency, your core constitutional rights are protected. The states cannot deny you free speech, freedom of religion, the right to a fair trial, or protections against cruel and unusual punishment because those rights have been extended to apply at every level of government. The only major exception is the Third Amendment, quartering of soldiers, which has never been formally incorporated, though it's rarely tested in modern times. In short, incorporation transformed the Bill of Rights from a narrow shield against federal power into a broad guarantee of liberty across the entire United States, ensuring that all citizens enjoy the same fundamental protections no matter where they live. I want to focus on the Due Process Clause. When we look at the 14th Amendment, one of the most important phrases is the Due Process Clause. It reads, "No state shall deprive any person of life, liberty, or property without due process of law." At first glance, that might sound like it's just about fair procedures in court, but over time, the Supreme Court has given this clause enormous influence in shaping constitutional rights. There are really two sides to due process. The first is procedural due process, which is about fairness in how the government treats you. If the state wants to imprison someone, take away property, or even suspend a driver's license, it must follow fair procedures, giving notice, offering a hearing, and allowing the person a chance to defend themselves. Without these safeguards, the government could punish people arbitrarily, and that is exactly what the 14th Amendment sought to prevent. Most importantly, the Due Process Clause became the gateway for what we call the Incorporation Doctrine. Originally, the Bill of Rights limited only the federal government, but starting in the 20th century, the Supreme Court ruled that many of those rights are part of the liberty that states cannot take away without due process. For example, in Griswold v. New York, 1925, the court decided that freedom of speech applied not just against Congress, but also against state governments. Later cases extended these protections. Mapp v. Ohio, 1961, brought the Fourth Amendment's ban on unreasonable searches and seizures to the states. Gideon v. Wainwright, 1963, required states to provide legal counsel to defendants who couldn't afford it. And Miranda v. Arizona, 1966, made clear that state police officers must respect the Fifth Amendment right against self-incrimination. Because of this process of incorporation, through the Due Process Clause, the rights in the Bill of Rights apply at every level of government. Whether you're in a federal courtroom, a state court, or just being stopped by your local police department, those constitutional protections follow you. In short, the 14th Amendment transformed the Bill of Rights from a shield against federal overreach into a guarantee of liberty nationwide. The second side is substantive due process. This goes beyond procedures to ask a bigger question. Are there certain rights so fundamental that the government cannot infringe on them at all, even if it uses fair procedures? Over the years, the court has said yes. Rights like privacy, the ability to marry, or the right to make certain personal decisions fall under this broader protection. One of the most celebrated liberties in American democracy is the First Amendment guarantee of freedom of speech and expression. This right lies at the very heart of self-government because it allows citizens to voice their opinions, criticize leaders, and debate ideas openly. Without free speech, democracy cannot function. It would be reduced to empty rituals rather than meaningful participation. The Supreme Court has consistently given strong protection to political speech, recognizing it as the core purpose of the First Amendment. Even speech that is deeply unpopular, offensive, or unsettling to the majority often receives protection because the principle is that government should not decide which opinions are acceptable. Cases like Texas versus Johnson, 1989, where the court ruled that burning the American flag as a form of protest is constitutionally protected, show that symbolic actions can be as powerful as words in expressing political views. In recent years, debates over free speech have extended to new frontiers. Questions about hate speech, online misinformation, and speech on college campuses illustrate the ongoing tension between protecting expression and protecting people from harm. While the U.S. protects even speech that many find hateful or offensive, unlike some other democracies that criminalize hate speech, the court continues to weigh how the First Amendment applies in the digital age, where ideas spread instantly and globally. So, freedom of speech and expression in the United States is at once broad, controversial, and essential. It gives space for voices that challenge authority, test boundaries, and sometimes even shock the public. At the same time, the law recognizes that liberty must be balanced with responsibility, a principle that keeps this freedom both vital and carefully safeguarded. But while broad, the right is not unlimited. The court has drawn boundaries where speech directly threatens public safety or undermines essential legal rights. For example, in Brandenburg v. Ohio, 1969, the court held that speech intended to incite imminent lawless action can be restricted. Obscenity, defined in Miller v. California, 1973, falls outside First Amendment protection, as does defamation, false statements that harm someone's reputation. Likewise, commercial speech, like advertising, is protected but subject to more regulation than political expression. Perhaps the most famous phrase capturing this balance comes from Justice Oliver Wendell Holmes, who explained that the First Amendment does not protect a person who falsely shouts fire in a crowded theater and causes panic. His point was that free speech is not absolute. When words create direct and significant harm, government can step in. Another central pillar of the First Amendment is the guarantee of religious liberty, which is protected through two distinct but related provisions, the Establishment Clause and the Free Exercise Clause. Together, they aim to balance the role of religion in American life, allowing individuals to freely practice their faith while preventing the government from imposing or favoring religion. At the same time, the Free Exercise Clause guarantees that individuals have the right to practice their religion without unnecessary government interference. This protection covers a wide range of practices, from attending worship services to wearing religious clothing, to observing dietary laws or holy days. For instance, in Wisconsin v. Yoder, 1972, the court ruled that Amish families could not be forced to send their children to school beyond the 8th grade because doing so would violate their religious beliefs. However, the court has also recognized that the right to free exercise is not unlimited. Religious freedom does not grant individuals the power to break laws that are neutral and generally applicable to everyone. For example, in Employment Division v. Smith, 1990, the court upheld the denial of unemployment benefits to two men who were fired for using peyote in a Native American religious ceremony, reasoning that allowing exceptions would undermine the enforcement of neutral drug laws. Similarly, while you may believe your faith requires certain practices, those practices cannot endanger public health, safety, or the rights of others. In recent years, debates over religious liberty have become especially prominent in cases involving business owners, healthcare providers, and employees. Questions about whether a baker can refuse to make a wedding cake for a same-sex couple, Masterpiece Cake Shop vs. Colorado Civil Rights Commission, 2018, or whether religious organizations can be exempt from certain federal mandates continue to test the balance between free exercise and other constitutional principles. Taken together, the Establishment Clause and Free Exercise Clause show how the First Amendment protects both freedom from government-imposed religion and freedom for personal religious practice. This dual protection has helped create one of the most religiously diverse societies in the world, where faith can flourish not because the government enforces it, but because the government is restrained from interfering with it. The Establishment Clause declares that Congress shall make no law respecting an establishment of religion. This means the government cannot endorse or support an official religion, nor can it take actions that appear to favor one faith over another, or religion over non-religion. One clear example is in public schools. Teachers and administrators cannot mandate prayer or devotional Bible readings because that would amount to government sponsorship of religion. Cases like Engel v. Vitale, 1962, where the court struck down state-sponsored school prayer, and Lemon v. Kurtzman, 1971, which established the Lemon test for evaluating government entanglement with religion, highlight the court's effort to keep church and state separate. Civil liberties take on their sharpest edge in the realm of criminal justice, where the power of the state is at its highest and the liberty of the individual is most at risk. The framers of the Constitution recognized the dangers of unchecked government authority, so they built strong protections into the 4th, 5th, 6th, and 8th Amendments to safeguard the rights of the accused. The 4th Amendment protects against unreasonable searches and seizures. This means that police cannot simply enter a home, search belongings, or arrest a person without proper justification. In most cases, they must obtain a warrant from a judge based on probable cause. The Supreme Court has applied this principle to modern contexts as well, ruling that things like cell phone records and GPS tracking require judicial oversight, because technology should not erase privacy rights. The 6th Amendment ensures that those accused of crimes have the tools to defend themselves. It guarantees the right to a speedy and public trial, the right to be judged by an impartial jury, the right to confront witnesses, and most famously, the right to counsel. In Gideon v. Wainwright, 1963, the court ruled that states must provide an attorney to defendants who cannot afford one. This landmark case established that justice should not depend on wealth, and that the promise of a fair trial requires competent legal representation for all. The 8th Amendment prohibits cruel and unusual punishment. This has long been a source of debate, especially regarding the death penalty and conditions in prisons. The court has used the amendment to strike down practices that violate evolving standards of decency, such as executing juveniles or the intellectually disabled. While the death penalty remains legal in many states, its application continues to spark constitutional challenges over fairness, method, and morality. Taken together, these amendments form a powerful shield against government abuse. They remind us that in the pursuit of justice, the ends do not justify the means. The state must respect the dignity and rights of every individual, even those accused of crimes. By protecting the accused, the Constitution protects us all, ensuring that liberty is not sacrificed to the raw power of authority. The 5th Amendment provides several critical protections, including the right against self-incrimination, the basis for the famous phrase, the right to remain silent. In Miranda v. Arizona, 1966, the court held that police must inform suspects of their rights before questioning them, ensuring that confessions are truly voluntary and not the product of intimidation. The 5th Amendment also prohibits double jeopardy, being tried twice for the same offense, and guarantees due process, which means the government must follow fair procedures before depriving anyone of life, liberty, or property. The right to privacy. Interestingly, the Constitution never explicitly mentions privacy, yet the Supreme Court has interpreted certain amendments to imply it. In Griswold v. Connecticut, 1965, the court struck down a ban on contraception, establishing a right to marital privacy. In Roe v. Wade, 1973, the court extended privacy to reproductive choice, though this ruling has since been overturned and remains hotly contested. More recently, privacy rights have expanded to issues like same-sex intimacy, Lawrence v. Texas, 2003, and marriage, Obergefell v. Hodges, 2015. Civil liberties in times of crisis. So, what can we conclude about civil liberties? They are not absolute. They are balanced against competing values, order, security, equality, and the rights of others. They expand through struggle, through court cases, social movements, and moments of crisis. Civil liberties embody the promise that government exists not to dominate the individual, but to protect and respect personal freedom. As we move forward, keep in mind this question: how do we balance liberty and security in a world of new threats, from terrorism to cyber warfare? That question is at the heart of civil liberties today. Next time in Chapter 10, we'll explore civil rights, shifting from the liberties that protect us from government to the rights that ensure equal treatment under the law. Civil liberties are often tested in moments of national security threats. During World War II, Japanese Americans were interned, upheld at the time in Korematsu versus United States, 1944, though later condemned. After 9/11, the Patriot Act expanded government surveillance, sparking debates over the balance between security and liberty. The tension between protecting the nation and preserving freedom is a recurring theme in American history. Civil liberties in the digital age today, civil liberties extend into new arenas like the internet, social media, and digital privacy. Debates over government surveillance, data collection, and online speech show how technology forces us to reinterpret old rights in new contexts. Questions like whether tech companies should regulate speech on their platforms remind us that liberty is never static. It evolves. Conclusion.